across the federal government. So my job is to support federal employees government-wide, and so I prefer you not think of me as GSA, but more as a federal access for you. We're going to be having a presentation on international contracts and the Defense Base Act. I will be introducing the presenter in just a few minutes, but in the meantime, I wanted to show you a few things about the webinar that kind of makes your life a little easier as we're going through. So first of all, we're going to do, you can see slides, these boxes to the right of your presentation, and so a variety of them are very helpful for you. You can download the presentation, and just by, here's a little picture of it. It was in color earlier, so I don't know why it's not in color now, but you can see it starts with GSA DBA, and if you click on that, you can download that. Follow along if you wanted to that way, or just follow along on the screens. If you have any questions, put them in the Q&A box. I will introduce those questions to Karen as we're going through the presentation. Our goal is to get things done kind of in the sync of what is being discussed so that you don't forget it later. But if we run out of time, we will first of all address them at the end, and then if we're still out of time, we will send you answers to those questions when we send the CLPs. So it's a process. We hope to answer all the questions during the presentation. Webinar materials are going to be emailed to you, the presentation slides, the Q&As if there's any that are still needed, and the CLP certificate. The CLP certificate is taking longer than we would like, so to be patient with me. I'm going to guess somewhere between 3 and 4 weeks is my average right now of when they come out of our magical system for which I have no control. So in order to help me get you a CLP, please make sure you type your name, your email address, your email address in this bottom box for CLP credit. That is really important. And I can tell you that if you're calling in, I have no record of you attending the conference because the system depends on you checking in here. So please, if you are calling in only, hang up and come back in on the webinar, and that way you'll get the full benefit of the slides as well as the discussion that's going on. Okay, now I'm going to be introducing your presenter. Her name is Karen Dobson. She specializes in helping government and its contractors with their own OCONUS risk management needs. She is an owner of GovCon Consulting. Karen has advice on how to save money and avoid mistakes when procuring overseas and OCONUS services. She had done the insurance broker for the contractor who held the log cap contracts for the global war on terrorism. Since then, Ms. Dobson has dedicated herself to understanding all aspects of the Defense Base Act, including when it's required, how it is implemented, how the government's own contracts affect the application, and educating contractors in responsible employee care. These things can cost you money, so it's great that you signed in today and you can get her advice. Here is Karen.
Thank you. Oh, I'm on. Can you hear me?
You sound great.
Okay, perfect. Thank you. Hey, thank you all for joining. I know that Defense Base Act is usually a really dry issue. Most people don't like it. Most people don't want to deal with it, and they would just wish it would go away. So the purpose of this presentation is to One, help you understand how, when you're writing your contracts and you're getting, when you're negotiating with your own contractors, what are things that could be important to you around the Defense Base Act. But also, in order to get to that level, to give you a little bit of background, the legal background, and also how it's implemented. So if you understand how it's implemented, that can also help you with understanding how you, when you write your contracts or negotiate them, how those affect this. Moving right along, your contractors care about the Defense Base Act because they care, the contractors have their responsibilities under the Act. They care because it's legal obligation for them. They have to understand where it applies. We're going to backtrack just a minute. So this is the outline of what we're going to talk about. So why your contractors care about DBA, we're going to go through how it works and why it costs so much, and then we're also going to talk about your own contracts. Can you all see the screen okay as I move through?
Yes.
Okay, thank you. Just getting used to the sensitivity here. Okay, so DBA realities for your international contractor. They're basically one of the most expensive line items that they have in their bid proposals. For the larger contracts, they first have their physical assets, then they have their G&A, and then third is their Defense Base Act cost. And Defense Base Act cost is the one that they have the most control over. And because they have the most control over that, it's one that is really important for both the contractors and you and the government to understand what factors go into creating the expense, and also understand how much that it's not a commodity, that it actually is something based in science. Let's see. And so also contractors care about their DBA rates because that makes them more competitive and successful. And you on the government side care because you have your own budgets that are impacted by the Defense Base Act insurance costs that the contractors have. The profit margins on the contracts tend to be small. Incremental savings make additional profit for them, so there's a profit motive in general. Winning contracts keeps them in business. Right now, currently, the best way to meet the Defense Base Act requirements is through insurance, and then also through insurance companies managing that. We're going to go into what, how a premium is generated, and what a loss history is, and how Defense Base Act loss histories are different from other forms of insurance. Next, we're going to talk about where DBA applies. And this is a place that I find that there is a lot of confusion. I'm going to backtrack just for a minute. Mrs. Duckworth said that I had been the broker for the logistics company when we were fighting the war on terror. And back then, we really didn't understand the full course and scope of how DBA applied. So we went into Iraq. The contractor supporting the troops hired local nationals. And if you can imagine, the local nationals, in this case, specific case, there were 4 washerwomen. And I am sure that they were ecstatic about being able to generate income for their own families and support their own families by helping wash the troops' uniforms. The next thing we know, they were killed by an IED, all 4 of them. And little did they know that now they were going to continue providing for their families, because what we learned in that moment is that the Defense Base Act applies to all nationalities. Any nationality that is funded or working on a contract funded by U.S. government money is subject to this act. And at that time, it was very hard for us to put our heads around the idea that a U.S. federal workers' compensation law would apply to employees who had no concept of what workers' compensation might even be. So going through that, again, we learned that this applies to any contract for work outside the United States, regardless of nationality. It applies to all employees and their subcontractors. So the prime contractor is subject to or responsible for the flow down of the requirement to their subs. I've also noted here where you can find a copy of the Act and its amendments. It's on the Department of Labor's website. Is where but of course, since it is a federal act, there are other places as well, but that's probably going to be your best site to go to. So, as I said, this is on the Department of Labor's website. The Department of Labor administers the application of the Defense Base Act, and it is only the Secretary of Labor who can grant a waiver or exception. There's rumor on the street that contractors within the government are deciding where and when the Defense Base Act applies. And I get it because it's confusing, it's hard to administer, and it's expensive. But actually, only the Department of Labor can say when it does and does not apply. And just to go on to the next slide. This is where things get really interesting. Even if Defense Base Act coverage is required under the contract and it's not included in the contract, the contractor is still responsible for buying this coverage. And if they have the coverage, then that's exclusive remedy. If there's an injured employee, they are reimbursed for their injuries subject to application of the Act. However, if there is no DBA coverage, the contractor does not retain those defenses. They are now subject to fines if there's an injured employee. Their C-suite can be jailed, which has not happened, but certainly is written into the Act. And if there's an injury to an employee, then the people in the C-suite can also be personally liable for reimbursing the employee for their claim. And just to put that in perspective, yes, is there a question?
Yes, Karen. Someone asked if DBA applies to personal services contracts.
Meaning, can you give me an example? I think the answer is yes, but just to make sure I'm answering properly, can you describe a personal services contract to me?
Alita, can you type in what kind of personal services contracts you had in mind?
Contracts with individuals. Yes, as long as the individual is funded by the U.S. government and there's a contract in place. The Act reads that it is a contract. So if there is a contract, there are exceptions to the Defense Base Act, and the main exceptions are if it's a grant is not considered a contract. And there's a list of countries, I have it documented here in the site so you'll have it as a reference, but there are some countries where if the Department of Labor has found that they have a responsible workers' compensation or social security system in place, then those local nationals in those countries are not subject to the Act, and they have what's called a waiver.
Okay, thank you.
Absolutely. So again, I think this slide is so critical as far as education and understanding that who can say the DBA applies or not. State Department PSCs. What are PSCs? Personal services contracts?
Yes.
I'm sorry, I don't see the whole question written out.
It just says, does DBA apply to personal services contracts?
Yes.
Okay.
Yeah. Okay. So just in summary, the Defense Base Act provides work. This is not the summary of the whole presentation. This is the summary of this section. The Defense Base Act provides workers' compensation protection to civilian employees working outside the United States on U.S. military bases or under contract with the U.S. government for public works or national defense or for national defense.
Okay, and I have some input from John McKinnon. He says that State Department personal service contracts are considered U.S. government employees and not eligible for DBA. So that's just a comment from him.
Personal services contracts for State Department are considered U.S. government employees and not DBA. Okay, I appreciate that. That's good information. And unless you're asking me if that's the case, it sounds to me like you're saying that's fact.
It's written as a statement, not as a question, so we'll continue on.
Perfect. No, I appreciate that. And if there's anything that you all know about your side of this business that I don't know, or because it's not included in this presentation, please educate me, because just to put this in perspective, I'm having this presentation with you all on the government side, and then in October I'm having another presentation for the government's own contractors, so the private sector. So I'm looking at this as kind of a bookend, an opportunity to share with you what I know, and also if there's something that you know that I need to know that I can also share with the public, then I think that creates a funnel of communication that we haven't had before. So, yes, Maureen.
There's another question from Alita. She's asking, is there a definition of public works?
Probably. I don't have it here, but I can use that as a follow-up communication piece.
Great. Thank you.
All right. Absolutely. Okay, so Puerto Rico, even though it's a U.S. territory, Puerto Rico is subject to the Act. A lot of people think that because it's just a territory that it is not subject to the Act, and because they've had so much restoration work down there, all of that restoration work being funded by the government is subject to the Act. Grants, as I said before, are not subject to the Act. And then USAID contracts are covered under a sole source agreement with a specified insurance company. And so if any of you are working with USAID, within USAID, then there's a set place for that insurance for the contractor to buy that insurance. Okay. I just referenced the statute here. I am not an attorney. I just am very committed to educating on the Defense Base Act itself. But if you need to have reference to the applicable sections, either within the FAR or the Act itself, here's some reference points for you. Okay, this is really the heart of this presentation, is why is the DBA so expensive? Okay, the way it works is that you have a contractor, and so you can use the analogy of, when you buy homeowners insurance. You go to your insurance agent, the insurance agent goes to the insurance company, and you, the homeowner, or in this case the contractor, pays premium to the insurance company. Right now, estimated costs for Defense Base Act are about $500 million. So this is not a small expense on the part of the government. So the contractor pays premium, and then what happens with that premium? Well, if the insurer uses that premium, and we call the insurer the insurance company as well, the insurer manages the claims that are made by injured workers or deceased workers. So here's some of the responsibilities that an insurance company has. They have to file and maintain the incident reports. They have to check medical histories. They have to pay claims. And if you can imagine back when we were going into Iraq the first time, trying to figure out how to reimburse widows who weren't allowed to have bank accounts. So the system for reimbursing injured workers or their families has really come a long way, but it's been a huge education process. There's something called war hazards claims, and the insurance companies are responsible for managing the claims, but they cannot charge a premium for them, and war hazards claims are usually bombs or bullets. So bombs or bullets are managed by the insurance company and then handed off to a special division of the government to make sure that the remainder of the claims are paid. Insurance company also maintain databases. They, again, make the payment challenges for foreign nationals. They investigate surveillance. They set up bank accounts. They look at the compensability evaluation. That means how much should the injured worker be paid according to the law. Manage evacuations. They handle the soup to nuts to making sure that anybody who is injured is properly brought back to wholeness to the extent that they can. Now here's an example. This is where people get really interested. What does an insurance claim look like? And this is going to be part of the root of our conversation. So here are 3 examples of claims that have come off of an actual loss run. So somebody tripped over a backpack. They were 59 years old, and that claim amounted to $166,609 just from tripping over a backpack. Claim number 2, a back strain by lifting and moving a cart. This person was 46 years old. They were in Iraq. That claim is now $962,099. This is huge. Example number 3, somebody slipped on a mat, age 44, in Kuwait, $209,635. If these claims had occurred under a normal, not normal, but a regular U.S. work comp system, you would be looking at example 1 would be maybe $20,000. Example 2 would be maybe $80,000. 3, $30,000. So the way that the Act is written and the way that contractors respond to how their contracts are written with the government have a direct impact on the escalation of these claims. So what can we do about this? Here's how the premium is determined. The premium is determined by looking at the historical losses that a contractor has had, estimating using so they take the historical losses and they project what they anticipate losses will be in the future. And they do it using statistical triangles. So the premium is based on remuneration, which is payroll. It's payroll, overtime, tips and bonuses, room and board, car allowance. So it's remuneration times a rate that then equals the premium. The premium has to cover those estimated losses, the administration of the claim, and profits to the insurance company. So they take a historical baseline of remuneration tied to claims so that as the contractor looks forward and says, I think my estimated payrolls are going to be X in the future, then the insurance company will say, okay, if you estimate your premiums are going to be X in the future, we imagine that your losses are going to be Y, and so we'll have to charge X premium. So it's based on historical data, it's based on statistics, and this just reinforces that DBA is not a commodity. Okay, so what can we do about this? The key drivers for the claims are that you saw the age of these claimants. So most of them are this is their second career. They are not going into this workforce without pre-existing conditions. They are going into the workforce with pre-existing conditions. The law says that the injured employee has to be brought back to 100% of where they were when they were hired. And if there are no pre-employment screenings to identify where that person, what pre-existing conditions that person might have, then they're tasked with bringing the person back to 100%, which is impossible. So that's a big driver of the force. I know that there's some, the CRC, the Combat Readiness Center, that's working to help this process, but it's still a big issue in this industry. I have under workforce composition nationality as well. It's fascinating to see how different groups of foreign nationals start learning about the Defense Base Act. So at one point in time, it might be we start seeing a slew of Filipinos, or we start seeing a slew of South Africans or Peruvians. So it's not that those nationalities are bad by any stretch of the imagination, or I'm trying to single them out. I'm just saying that this is a phenomenon that we see that occurs based on where different contractors are sourcing their labor supply. Often we see that skills aren't matched with the job description. Somebody who has a pre-existing back condition is tasked with lifting 50-pound compressors. So there just really needs to be an alignment on the part of the contractor that they're hiring people who are actually capable to do the job that they're assigned to do. Then there's also just the nature of the act. The claims are litigated with administrative law judges, and the administrative law judges, traditionally, this is kind of changing, do often favor the employee and making sure that they have the proper reimbursement that they feel they are due. The Defense Base Act applies to what is all activities associated with that contract while the person is overseas. So that means that even if the person, okay, say they're in Afghanistan, even if the person says, great, I have free time, I'm going to go work out in the gym, and they get a strain in the gym, that strain is subject to the act. And actually, gym claims are a huge problem, because often that's all people have to do is go work out, because it's not like they can leave the base or go do anything else, and they have to maintain their BMIs. So yeah, gym issues are a big issue. Injured workers have to be rehabilitated to the same health. I was mentioning that before. This is the part that I think is incredible about ambulance chasers. Some of the contracts that are written, especially I believe in the State Department, say that that employees are what are called bio-placed. So an employee has to meet certain criteria in order to be employed. And if that employee is injured overseas, the contractor is not paid paid for the use of that employee. So the employee is sent back to the United States in this example, and the lawyers are putting representatives on the plane sitting next to employee coming back to the United States, educating them on how to file claims under the Act, and maximize their compensability before they even hit the ground back stateside. So there are also parts of contracts that I understand that say, let's say the employee is brought back to the United States, then the contractor gets paid even more money to have to train a new employee to go replace the injured employee. So there's not an incentive on the part of the contractor to retain the intellectual capital of the injured employee, and then the injured employee doesn't have a job to go back to. So these are just things to consider. I'm not giving any perfect ways to handle this, but I am asking just to consider as you put these contracts together what might be issues. Let's see here. Gym claims are probably 80% of our claims. Okay, yeah. And the gym claims are tricky for you guys because we could say, hey, let's put video in the gyms and see who's not taking advantage of this process, or who is taking advantage of trying to file a claim. But because everybody's under clearances, you can't use the video. You have to protect the integrity of the clearance. We also have what's called the zone of special danger. And the definition, how the zone of special danger is applied, has just grown in a way that I don't think any of us saw. So if there's we had an example of somebody who needed to go help with loss control management for a major contractor. And that person wasn't employed under a specific contract, but he was going to be going to the base. So as long as he was going to the base managed by this contractor, he had to have Defense Base Act cover. And that was run by an attorney. We ran that one by an attorney because it just seemed like it was expanding the law beyond what the course and scope would be. So again, if you consider the types and requirements of your contracts, it's anywhere from firm fixed cost to cost plus. Cost plus is really easy for a lot of people because then the contractor says, great, I have this expense and I'll just hand it over to the government. And then the government says, great, we'll pay it. And I understand that there is a need for cost plus contracts. So I'm not trying to say that contracts should be cost plus or not cost plus, and just again asking you to consider what the impact might be for your own contracting, your own contractors. Firm fixed cost is really tricky for contractors as well, because often they are being asked to estimate what their costs are going to be over a 5-year period, a 3 to 5 year period. And trying to estimate with the Defense Base Act cost being such a significant part of that projection, it really puts the contractor at a disadvantage because different things are going to drive the Defense Base Act costs. There are the individual losses on the part of the contractor. There's going to be the overall results of the insurance company themselves. There are going to be places where activity increases that wasn't anticipated, that's going to have a direct correlation to the losses. And it's just really difficult for a number of reasons for a contractor to project what their expenses with respect to the DBA are going to be on a firm fixed cost. So there has been talk within the government about the government having their own insurance program, and that's what we call a sole source program. And there was a sole source program for the State Department, and there was a sole source program for Army Corps of Engineers. And in those sole source contracts, whenever a contractor said, great, I've got this new business, I'm going to go get my DBA, and here are the rates. I have guaranteed rates. Because they had guaranteed rates, there wasn't an incentive for them to manage losses to their own employees because there was no financial impact on them if they had a lot of losses. I hope that makes sense. Let's see, I see that there's a question here. State Department armed contractors must pass fitness tests before deployment and during, and there are, okay, so you are putting cameras. I knew that cameras were there, I just didn't know that they could use them. And yes, they are having to pass a fitness test, but that doesn't mean that they're using technology that helps screen for pre-existing conditions. And there is technology out there that they can do that. There are a lot of HIPAA rules around how they can disclose this, or what can be disclosed and when. And it's getting better, but again, the fitness tests are important, but it's not a pre-existing condition. And I'm reading the question, trying to read the question. Let's see. I think moving on. So we've talked about what can you do, just really considering contract language. Again, if you don't include DBA in your contract and the contractor is subject to it, the contractor is still responsible for getting it. And they, camera's done by contractor, not government. Okay, thank you, John. This is a good conversation. I've addressed most of these. One thing I've wondered is, can there be cases where they employ rehabs while they're still overseas so that they aren't having to take all these plane rides and being educated on how to file claims and running up the cost of claims? A lot of times the contracts don't have a line item for a safety manager or a group doctor. There are cases where they do include a medical person, but safety managers are critical, and they are trained in helping to reduce injuries to employees. And when you're dealing overseas, yes, things are getting so much better than they were, but it's still something to take into consideration. Some of my contracts, there's some real specific contracts that have higher than normal losses, and you'd be surprised. It's contracts that you would think are pretty innocuous. But if you have people who you're bringing over who aren't trained, don't have military training, and they're put in a military environment, they tend to have a real hard time. And if you have a contractor that says, look, my DBA is so expensive and I'm having trouble with it, ask the contractor for their loss runs. You have every right to look at what kind of claims those contractors are having. If you see that there are a bunch of trip and falls, or as this gentleman was saying, 80% are in the gym, you have that right to look at that and what's driving those claims. And that can also be a helpful criteria in identifying whether or not that contractor is really somebody who deserves that contract. I'm sure there's so many other criteria besides Defense Base Act, but it could be interesting to look at, is the contractor really being a responsible employer? You can always ask for requirement of their loss control procedures. Usually those are really thick manuals. Everybody should have one. I don't know that you want to actually read through them, but it might be good to know that they have them. And I know exactly the contracts that you're talking about here. In the question section, they do full med clearances on armed contractors. And I think I know exactly which contracts you're talking about there. And yes, they are starting to get better about this. And that's where on this last item, just really thinking about baseline testing for employees. I'm curious, when you say full med clearance, how detailed that is. That might be a conversation for a different time, but it's good that the process is evolving to that level. Okay.
Karen, there's a question here. Is there a PD available for a safety officer? Not sure if we would add it as a full-time, but it might be an ancillary duty.
What's a PD?
Oh, a position, a description. I'm sorry, we speak government so easily.
I know, it's so easy. A position description. Yeah,
for a safety officer.
I can get you one.
Thank you.
Absolutely. That's a great question. Like, how can you include something that you don't know what it is? So, there are reference sites. The Department of Labor has a very, let's see, what did you say? I'm not able to see the full question. It says qualifications, requirements.
He wants to know the qualifications, the required experience, and the job duties. I think that would all be in the PD.
Yep. Thank you. Appreciate you reading that out for me. And so the Department of Labor, who has oversight, it showed up later. Okay. The Department of Labor has oversight responsibility for the Defense Base Act, and they have a really fantastic site. It's got a lot of great answers to frequently asked questions. It's got past presentations by either members of the Department of Labor and other people and from other conferences, Defense Base Act conferences. There has not been a Defense Base Act conference here in the DC area for over 5 years. So that's why I'm doing this one in October, because there's always new information. There are always case studies, creative ways to understand how to manage responsible employee care. Is responsible employee care evolving? So I'm just super excited to see what's going to come out of that, and also what's going to come out of this conversation, because already I really appreciate having this opportunity for dialogue, even if it's through Q&A. Waivers. Waivers are where you do not have to include DBA, and you can find that list. It's updated regularly by the Department of Labor, and this link will take you to the waivers. I also mentioned the Department of Labor has frequently asked questions. Can I provide information on the DBA conference in October? I sure can. Maureen, I believe I sent that to you. Or is there a different way you want me to respond? How about when I respond to the question about the PD for safety officer, I'll include a link to the DBA conference. And that way we'll cover both of those. And then if there are any other questions that come up in the meantime, we'll put that in there as well so that we're efficient with the communication for you guys.
Great.
The Department of Labor has cleared certain insurance companies to write DBA. Most insurance companies the list is huge, like 200 companies, but really there are only basically six companies that are writing DBA and are legitimate companies. They're AIG, Allied World Assurance Company, Chubb, CNA, Star, and I'm missing one. AIG, I'm not sure I said AIG. I did. Okay, so AIG, Allied World, Chubb, CNA, Star. There's one I'm missing, so I apologize for that. You can always ask for a certificate of insurance that from the contractor verifying that they actually have purchased the insurance. The big guys will absolutely have it, but it might be a little bit more challenging for the little guys. Also had an example I'll throw out there of a major contractor in the area. They had somebody go in and look at their Defense Base Act cover and found out that they were only reporting those employees who were associated with with a base. They were not including their employees who are going outside the wire or on other, maybe doing embassy repair or doing work that wasn't directly associated with the base. They were taking the name of the act, Defense Base Act, literally. So that's another issue for contractors. We feel like everybody's educated, but it's a constant process. And then whoever might have a USAID site, AID contract, here's the site for that. And that's pretty much it. I just really wanted to appreciate having this opportunity to talk about the Act, what drives it, how it can influence your contract, and how your contracts can influence it. So are there any other questions or things that you want to ask of me? No? You can always reach me by way of Maureen. She has all my contact information, and I'm more than happy to continue this dialogue, or if you want to speak to me directly, I'm happy to do that as well. I love having an ability to keep an open line of communication as these processes.
Mute off.
We're going to give you the capability to unmute yourself if you had a question that you'd rather speak rather than type. This is your chance to do so. And I see that a lot of people came in without their phones when they signed in. So typing may be the best method at that point. Okay, Richard asks, when requesting, hang on for a second, when requesting loss run data, how many years of data should be requested?
Beautiful question. 3 to 5 years is normal.
Okay, thank you. Is there someone at Department of Labor that can make a determination as to whether DBA applies or not?
Yeah, that's a fantastic question as well, because historically they've deferred to the law judges, and they have not been able to make a definitive statement DBA applies or doesn't apply. Certainly, I let the Department of Labor know that I was having this conversation. They may be on the line and can respond to that. But it's tricky getting a definitive answer, which is part of the fun of doing business with the government, right?
Oh, that's sad. Okay. But it does sound like a dangerous question, so I can see that
it's a great question. I've tried.
Okay, do we have any others? I thought I had seen one earlier, but...
Under the Department of Labor site, there is an email address where you can write a letter. You can email the leadership responsible for DBA, and they do respond, but it may not be as a yes or no like we would all like.
And yes, someone has asked if we will provide a recording of this training and the Q&As. Yes, the recording of the training gets sent to central office and actually is made 508 compliant, and that is a human being is actually doing that translation of all of our speech. So that takes a while. So that will not come in the initial email, but it will be posted on the professional services hallway of the acquisition gateway when it is done. So please go there and look, but I would say that it's going to be at least a month before that 508 compliant video translation is done. The Q&As will come in an email from me. I could vaguely hear someone in the background. Perhaps if you're asking a question via your phone, if you could speak up or check your volume. Okay, are there any other questions? Well, Karen, thank you so much for starting this conversation.
Oh, thank you.
It's an eye-opener.
Maureen, one more question came through.
Okay, good. Have you seen DBA costs as a separate evaluation criteria in a solicitation?
No, I have not.
But you're recommending it, if I remember correctly.
I think it's worth a conversation. I hesitate to say I'm making a recommendation, but it is a very expensive part of the acquisition process. So to be aware of what it is and what drives it is really the bigger point that I'm making here. I don't know that anybody's actually used that as a driver. I think it's an interesting conversation.
Okay, thank you. Okay, going once. Going
Thank
twice.
you. I really appreciate the time.
If there's no more questions, thank you so much for doing this. We really appreciate it. And we will be, trying to do these spotlights about once a month, so look for advertisements. And we really appreciate Karen putting the effort into this and your attendance. Have a good day, everyone.
All right, bye-bye.
Bye.